An MSA provides a framework or a backdrop for two businesses to do business and have many deals kind of on a rolling basis.
It defines the rules of the game, just simply, right? This is how we're going to play. This is what I expect of you and what you should expect of us.
Welcome to the Land Department Podcast. The state of land and energy as we see it.
Brent, we moved to over the ears. Looking good, man.
I mean, maybe I'm legit. I'm more of an imposter than anything, but I got the buds for it now. I'm set.
Looking the part, man. Looking the part. Well,
this is where it all goes downhill.
Well, we could say earmuffs. I'm sure there's plenty of situations where MSAs have needed some earmuffs in the room because it went wrong so bad. But we're talking about master service agreements, and we've got Molly Pela with us. How are you?
I'm well. Thank you for asking. How are you guys today?
We're great. We're great.
Doing
Brent, you
great.
met Molly. You've probably known her a while, but I know you mentioned that you were at a presentation she did on MSAs and you wanted to have her on. How did you?
Yeah, certainly. Met Molly. You know, we've got friends over at Oliva Gibbs, Zach and Brad, and we've all been good buddies, worked together in the oil and gas title side of things, and we're kind of business strategy buddies. We talk about all kinds of stuff, what we're doing with our companies. And so met Molly, probably 6 or 8 months ago at an event with Zach and Brad. And then they put this article out and I said, wow, that's a great topic. It's kind of like your greens, you have to go through it and have to take them and eat it, but you don't necessarily have to love it. But it's very important. It touches for landmen, especially on the brokerage side, and ultimately through the field landmen that work in the space and for and through brokers. It affects everything they do, and every in-house landman in large part is, whether they realize it or not or have to deal with it, the work that we're doing for them is subject to a master service agreement. So thought it was relevant and maybe something that not everybody gets to touch or deal with. So Molly's going to share all her wisdom from litigating when these things go wrong and advising her clients on what they need to include and what they don't, from her perspective. And then I'll share, from a kind of a service provider's perspective in the land space, the things that we look for and considerations that might apply to the work that we do as landmen. So it's going to be exhilarating.
Well, Molly, we were talking a little bit before this, and I had asked if you had any stories of MSAs going right and going wrong. And you mentioned that you really only hear when it goes wrong. So if a good MSA is executed, you'll never really hear about it. But what is an MSA? Give us the definition, make it really clear for us, and then what a successful one should do.
Sure. So an MSA provides a framework or a backdrop for two businesses to do business and have many deals kind of on a rolling basis. So it's setting a baseline, and then as jobs change, depending on what's needed, depending on if you're at different tracks, different well sites, or anything, it allows you to make the subtle changes that you need to for as the job changes, without having to renegotiate, starting soup to nuts on the whole deal. You've already got the backdrop with these, this set of terms. That's always going to be the framework, and then it's just kind of tweaking the 5 points of it specific to various jobs.
And how often are these updated in general? I mean, obviously it varies partnership to partnership, but how often should they be updated?
Well, fair enough. Sure. If your businesses change, a lot of times, companies will change operating, and there'd be different divisions and different arms. You certainly want to make sure that you have an MSA with the right entity, and the other entity that you're dealing with, if that changes. I mean, practically, every 3 to 5 years, because you'll want to change different things. Interest rates may change, or, you may decide that, hey, we initially agreed to 45 days for payment, and that doesn't really work for our business, and we need to change it to 30. And so, and that may be across the board. You certainly can do it with any individual entity, but you may need to make some business decisions that need to change with that. Laws are always changing. Cases are always coming out to interpret these things and everything. And you don't want to have old inapplicable language, that you're trying to come up with, or, things that if the court says, by the way, this doesn't mean what you think it means, well, that's a real good time to start looking at it and making those changes. And then, of course, one of the things that we recommend in your MSA is that you put a term in there. Look, you can put the term for 10 years if you want to. And certainly you would want to take a look at them before it expires or shortly thereafter.
Yeah, I mean, what we tend to see in the land space, as land brokers is um, about half of them are 3 to 5 year terms. The other half are so long as services are being provided. And that's the ones that'll get you. That's how they come to us. You don't want a perpetual agreement, right? Because oftentimes as a service provider, you're bound by certain obligations, confidentiality, audit, access. All those things are parts of those things that when you sign off, you're agreeing to abide by them. So if you work for a client for a year and don't work for them for 10 years, but you still have a service agreement that has all those binding, restrictions or conditions, those things you don't want that lingering over you. Some of our clients modify them yearly. Others, it's a 3 to 5 year cycle, and some of them they're perpetual. So that's where all that termination language, all the kind of the things that linger, you want to really make sure you have a term on those lingering things if you can help it.
Well, let's dive into a little bit more of the advantages of an MSA. We're going to talk about some disadvantages as well. But for advantages, why does it make sense to do an MSA with a partner that you envision doing projects with long term?
Efficiency is probably the easiest one. Again, it prevents you from having to soup to nuts, start over at square one. If you're already 80% of the way there, 90% of the way there, because you have a master service agreement with contracts that you've already, or terms that you've already agreed upon that are good for this project, that makes sense for this project, then it's a function of, okay, it's going to take us, 4 days and we need 6 guys and this is going to be the hourly rate. And that's what's going to happen for this. And you don't have to worry about when payments going to be made and, indemnity provisions and, much what Bro was talking about of, confidentiality provisions and non-solicitation and, all of those things. Those are already in place. Those are going to continue from job to job to job to job. And all you've got to do is deal with the specifics of this particular job. And it allows work to flow much faster and keep, I don't need to tell you guys, time is money, particularly in the oil patch. So it allows for that efficiency and allows a little real world acknowledgement that things move quickly.
Yeah, it defines the rules of the game, just simply, right? This is how we're going to play. This is what I expect of you and what you should expect of us. It allows a mechanism and a structure that allows you to adjust your rates, to set scope, maybe you're working in multiple basins for a company, and you have a rate schedule and maybe an expense reimbursement schedule for landmen that varies from basin to basin, location to location. If you have that MSA in place, you have a structure that allows you to set the rules so that this is what I am allowed to bill. This is what you agree to be billed. And there's no argument. We've had the discussion. It's done at the beginning. And, this is how we're going to operate. It also is good for, the insurance requirements and all the other things that we're going to go through today, just kind of as we kind of dissect a standard MSA, to know what's expected of you as a service provider and what that company's standard operating procedures are going to be with respect to their vendors. So lots of pros there. And we like to do it because it gets that out of the way. Just set the rules. These are the collections. These are the billing requirements. So many of our E&P clients have very sophisticated billing requirements. You have to use this system and reference these numbers and put this code. And if you are relying on a bunch of landmen to go back and forth to give that information, sometimes you might not get it right. So when you talk about pros, that's definitely it.
Well, I'm sure there's also a level of stickiness too. Like if you have to go through that process with so many different brokers over and over and over again, you're going to use the one that you don't have to go through with it again because you've already have it in place, right?
Yeah.
And then you're saving probably a lot of money because once you have it in place, you're not having to do that over and over on project to project, right?
Absolutely.
Yeah, exactly.
And so let's talk about more of the pitfalls. Like when does it not make sense to do an MSA?
Yeah, if it's a one-time kind of deal, it may not make sense to do it. If it, y- you know, if it's a very short-term kind of deal that's almost like an invoicing, it may not make sense, right? There all the time you got to make business decisions. Look, these MFAs can get complex. They can be, dense. Sometimes you can agree to things that you don't want to agree to simply because you're like, nope, let's get our guys out there, let's get them going, like, let's start doing it. If it's not a company that you anticipate really a long-term relationship with, initially it may not make sense. Of course, if that leads to more things, then it could make sense. And particularly with some of the larger companies that exist, these deals can be very one-sided, and they may not be so flexible
Very.
on terms. And it will be either you agree to this and do it the way that I say you're going to do it, or you're not going to be out here for my job. And so there are some things to consider as far as that goes about whether or not how important that is to your particular business and what you're trying to do.
Yeah, there's the disadvantage to having an MSA, and then there's whether or not you want to enter into one, right? And those are the business cases. And it goes back to what you have to subject yourself to. If you're running a good business and you're you know trying to operate under best practices, if you sign an MSA, you're agreeing that you're going to live by it, right? And it's something we do. I go through these things and they're painful. A 70-page MSA is damn near waterboarding. No matter how much is on the other end. And especially when, it's a particular client who's got a big stick and they're going to tell you what your earnings are going to be. And maybe that isn't economic for you. And there are times when we review these things and say, look, I'm going to have to spend an extra 20 grand a year for your insurance requirements. And you're offering me a 2-week job with one landman. That just doesn't make sense, financial sense for us to be able to adhere to this agreement for what's potentially out there. As far as times that a scenario where having an MSA is a disadvantage from a broker standpoint, it's the small jobs. You don't want to sign a service agreement that has non-compete provisions and all these non-solicitation, all these different provisions for a small, lease check over one section in the hottest part of New Mexico, right? You're going to subject yourself to potential non-compete in the middle of this area for maybe not that much return. So you still do the work, just don't have a service agreement in place. And in writing, you don't have those things that you're subject to. So they can be restrictive in that sense. And there's maybe times that we say, you know what, let's just do the work. If you're not willing to strike a non-compete, then we'll do this old school.
Yeah. Molly, you had mentioned earlier that a lot of these MSAs with larger companies can be pretty one-sided. What are some examples of that one-sidedness?
I've seen it again. I only know when they don't work. I know it's different when they do work, right? Because it's a problem. But yeah, I reviewed one recently from a large company that said basically if they weren't paid in a timely manner, if the invoices weren't paid in a timely manner, then they had the option to take a lien out on the company's accounts receivable, the entire accounts receivable. And I thought that is a very drastic measure for it. And, I'm really fortunate and glad that our client asked us to review that because I struck that language expecting some pushback. And they didn't. But, I'm wondering now how many people have just signed that and have now subjected, their entire business basically to a lien so that this company can get paid. And, I don't know how many of you guys have dealt with liens previously. It's not that super easy to unwind it necessarily. And it's judicial intervention in all of these things. And then of course it's not, then it damages your reputation within the community of like, we had to go put a lien on them to get paid. Well, you could be talking about $4. You could be talking about $4 million. Like there's a whole span in there. And of course, everything, the details don't become so important. It's just, I had to put a lien on ABC company because they didn't pay me, which they were entitled to do. But, it's things like that that can be very, very one-sided. The legislature has worked to balance those out, particularly with indemnity provisions. Some of these old MSAs used to be, you're going to be responsible for everything out there, whether it's my fault, your fault, the dog's fault, the wind's fault, anybody's fault. It's all you if you want to be out there. Unfortunately, the legislature and the courts have balanced that out and require, reciprocal indemnity, and that I'll take care of mine, you take care of yours. And there's got to be things that are back and forth for that to even be enforceable. And if they don't meet that, then, it's not going to be anything. Yeah, they used to be pretty oppressive, and waterboarding is a good analogy, I think.
Molly, that's not that there used to be oppressive. They still are in some cases.
Yeah.
But it's, things that we see that are very one-sided. And really, for the most part, most of the clients that we work with, and we've kind of reviewed 100 of these things, 200 of them over the last 10 years, that generally folks are willing to work with you. Where it's one-sided is whenever they slap a piece of paper in front of you and say, take it or leave it. And there's no practical discussion or conversation even willing to be had, where, hey, this service agreement that you put in front of me is clearly drafted for a frac crew and not a land service firm, right? So you're telling me I have to comply with OSHA requirements, HS&E requirements. I've got to have a safety program in place to have a landman sitting in their room running title on inverse. Those things, that's very one-sided. It's not practical. They won't allow us to strike it because, their posture is, we don't accept changes, or it's going through a procurement group that's not knowledgeable. Maybe they're an international procurement group that handles procurement for, Apache, or something like that. And they're looking at a global sense, versus, a land company doing land work in the lower 48. So, things like that. One-sided is payment terms, when they, say you have to bill us once a month and it's on a net 60 or net 90, I've even seen. Well, that's significant if you're a smaller group that's having to float that payroll for a long time before you're ever going to get paid. And rarely do companies actually pay when they say they're going to pay. So you just tack on another 15 or 20 days to the back end of that. That, and the third one has a big effect on landmen is just the insurance requirements. Some of them have just crazy amounts of insurance that are above and beyond really the exposure that they would have for a land services firm doing land work. So, if you can't get any movement on there's times you're going to have to pull out the pocketbook if you want the business, to make sure you can adhere.
Yeah.
Well, all in all, it hurts at times,
Yeah.
but it is what it is. And that's the business decision, it's a business case as a service provider, do I want, is there enough on the back end? Is the carrot big enough? And then you make those decisions as to whether you're, can comply and are willing to take the risk if you're not in compliance, I guess.
Yeah. And we've talked about this in the past, but if someone's so one-sided in their MSA and they're not willing to change it, is that really someone you want to partner with and align with, right?
Yeah. The unfortunate thing is sometimes the land person you're working with is a great, reasonable, practical person. They don't have, and maybe the whole land department, but they just maybe don't have any weight within the company, to actually champion, your request and champion the change. So it's sometimes just out of their hands, but you got to make a hard decision at times.
Yeah. Well, we've referenced an article already that's on the website. We'll put it in the show notes, but in there's a really great checklist that I kind of want to walk through, Molly, and just get your kind of feedback on what to look for, what to be aware of as you go through drafting or reviewing an MSA. So maybe you have it pulled up. If not, I can kind of run through each one. But, as we get into, let's maybe start with the term. What is something important when you're looking at a term for an MSA? We've kind of covered that a little bit already, but anything that we've missed?
No, you just want to be specific about it. And, again, it's whatever makes sense in a particular situation. It's not, as much as the MSA is kind of a one size fits all a little bit, but you need to make sure it makes sense for the two companies that are entering into this MSA and what makes sense for that. And so you may have, in your company, you may have, say you have 5 MSAs. One may be 3 to 5 years. One may be into perpetuity, although I'm with Brent. I don't love that. One may be for a year and one may be, for 6 years or something as far as that goes. It depends on what makes sense. It depends on what, kind of your needs are and everything. But it should have a term that is in there that is defined, and not so long as services are being provided is a little bit is our recommendation, simply because it gets very vague. It's very, if they buy a part from you, does that count? These types of things, and it can be binding even though you don't intend it to be. So just put a number in there. I think most folks are pretty reasonable about that, but just put a number in there.
Hmm.
Yeah.
Brett, do you see an advantage to going shorter or longer in term?
I mean, there's not an issue with going long. It's a matter if you go too short, then you're potentially, you get into working and you're active and you're just in the business, the flywheel of what you're doing with that company, and you just kind of sight unseen, you forget about it. So you don't want it to be burdensome from a maintenance standpoint. But again, you don't want it to be in perpetuity. And so I like personally that 3 to 5 years. I can throw a calendar, reminder on my calendar 5 years from now, and it'll pop up one day, and hopefully we're still around, and I can call somebody and show them how responsible we are to monitor our MSAs. So I guess the next one is scope of work. And, I can take that from our standpoint. It's pretty important. And the reason being, at least in our boilerplate MSA, and really kind of what the standard industry, landman industry non-compete is, typically goes something like this. 12 months from the date services are completed under a given work order, you won't negotiate for purchase, leases, minerals, royalties, whatever, on the lands that are subject to this service agreement or subject to a work order. Basically, what they're trying to achieve, and rightfully so, is you're not going to receive confidential information about a prospect area, work it on their behalf, receive payment on their behalf, and then come back and either A, work it for another company, a competing company at a later time, or go in there and buy minerals under their project. You receive a tremendous amount of confidential information on these projects, and the company needs to ensure that they're protected from you going and competing against them with their own information and know-how. So that's the boilerplate of what you see. And there's some nuance there. We always try to expand on that to account for scope of work, and really define what the creation of a non-compete area is. And that scope of work is a big part of that. If you have those limitations, for instance, we don't want to create a non-compete for doing a lease check or doing a filing for you or a mail out over, an entire, water flood unit, for instance. That takes us 3 weeks. It's cursory in nature. We get a list, we mail some stuff out for you. We don't want to be subject to a non-compete over a large area. Due diligence is another example. These projects cover counties at times. We don't want to subject ourselves to that. So the scope of work is important because it should tie to if you have a well-drafted non-compete, scope should be an important part of that. There should be definitions of what's going to create that non-compete and what's not. So it's a big one for us. I jumped in on that one because it's important.
No, and you're absolutely right. And, look, at the end of the day, right, this is a contract. And, if and when things go wrong, courts are going to look at it and going to, the vague and ambiguous terms are going to be ruled against he who writes it. And so specificity and clearly defining the parameters in which the parties are able to work and operate in different things, it's very important. And that way everybody knows. I mean, Brent, you said it perfectly at the beginning. It's the rules of the game. I play any game you want me to play. I just need to know what the rules are. And everybody needs to play by the same rules, because then we know how to move forward and what's going to happen. And so it's just setting those parameters and being very clear about it and being very intentional about it. And, I'm a firm believer that your contract, you should mean what you say what you mean. And if you mean it to apply to this project for this work for, much what Red's talking about, but not for, I need you to mail out some notices. Let's put that in there. Let's make sure that we're clear about what it is that we're talking about, so that everybody knows where we're going and everybody knows what the rules are.
Yeah, that's
Certainly.
great.
we could dive into that a little bit more.
Yeah.
Typically, you see that in the confidentiality portion is where you see non-compete. Can expand on that when we get to it a little more.
Yeah. Well, and speaking of kind of the rules of the game, and knowing what you're trying to achieve, performance metrics is also another area in the MSA that we want to review. What are some things that we're looking to really be clear about in the performance metrics section?
I mean, basically what's okay and what's not okay of what it is that I'm expecting your work to provide to me. Now, look, I mean, particularly for landmen, if you're hunting down and trying to get, track title down and everything else, well, obviously you're only as good as the information that you get, right? And so it's that, but there should be some, parameters around that of what the expectation is. Did you Google John Smith, Shelby County, Texas, and say, well, there's nobody there and move on? Or, well, there's 50 and I can't decide which one's which. So I'm out. There's some integrity that's involved in that, and it's what it is. But do you have to go knock on every door of every John Smith in the state of Texas? That's probably, but just setting your expectations and setting what it is that is acceptable work product outside of, industry norms and everything else. But if there's something specific that you're looking for, then put it in there.
Yeah, and we see it kind of in this. If you're looking at an MSA, I could see them in my sleep. They all kind of follow a rhythm, and that metrics that we see on the land-based MSAs is, things like we'll ensure that you have qualified independent contractors or qualified landmen with certain maybe levels of certification, or you'll follow best practices, or you will adhere to the code of ethics of the AAPL. Those kind of, we see those things oftentimes in that part of an MSA. They oftentimes, what you have to be careful about, and we didn't have in here, it's very warranted to add, there's the independent contractor employee relationship. That's a big deal in our space. And if you're not careful reading through these agreements, they'll plaster references to employees. Dudley Land Company will ensure that said person does this and does that. And by law, Department of Labor standards, there are things that I can't assure that a contractor is going to do, right?
Mhm.
It is not my responsibility to monitor it. And further, I cannot monitor it or I'm in violation, and I'm subject to penalty, and I'm treating that person like an employee instead of an independent contractor. So those are real important things to really study and make sure that you're not just signing off on, because, if your firm is big enough, one day you're going to be subject to an audit, Department of Labor audit, some kind of audit. They're going to look at those things, and they're going to look at all your MSAs and say, well, you signed off, and they'll use that against you, I guess. If you sign 15 MSAs that say you're going to treat everybody as such, that's an acknowledgement that you're treating those people as employees. So that's kind of one of the things to keep an eye out for from our perspective.
Yeah, and to that end, I'll just tag onto that real quick. The difference between independent contractor and employee is huge from a legal perspective as well. Simply because, much like you're saying, you'll expose yourself or your company when you don't have to. That's the reason you hire independent contractors. You hire somebody that knows what they're doing, and you can sort of reap the benefits of it. But you can't control it's the manner, means, and details of their work, right? So saying, I need you to go do this on this particular tract of land, that's not controlling it. If you're out there and say, okay, now you need to do this, now go to the courthouse, now look at these deeds, now go talk to this person, now do that, like it gets blurry. And so, a little bit, at the beginning, when you talk about the definitions and how things are defined at the beginning of the MSA, make that very clear. But best practices on my end is to not have employee means independent contractor, borrowed servant, like all of these sort of classifications. You want to continue to be very clear about independent contractor, independent contractor, independent contractor.
Yeah. And most of the MSAs are caught up with that, right? Companies have realized, hey, these are independent contractors. I want to make that very clear. So it's great. I've seen a big improvement over the last 10, 15 years in that side of things, how this typically is drafted. But they'll slip some stuff in there on you if you're not careful.
Yeah.
Payment and billing. Ooh, this is the good one. We touched on that, and really it's important. Generally, you want to make sure you can survive it, right? We like to look at these things as am I in compliance through my normal course of business, right? And so if you bill every 2 weeks and that's standard every 2 weeks, you want to make sure that it says, bi-monthly or bi-weekly or however it goes. Some of them will be at standard 30 days, where you bill monthly, and, you may not want that. They may not fit. So you want to look at that. You want to look at your collections, when they're obligated to pay. Depending on the type of service company you have, you may have an interest tacked on for non-payment or late payment. Personally, we have it in some of ours. We don't do it, but we've always got that stick, if somebody's late with payment. But you want to know what's there. Typically in that billing, you'll have some level of instruction too, hey, that requires you to use X system. You got to submit through open invoice, or you have to submit, using these codes, and it allows you at least kind of talking about the rules of the game. It gets that administrative process defined in your agreement. So really want to study through that so you don't start throwing out your invoices, for the first 3 or 4 or 5 months and realize you haven't collected because all your stuff's been voided. It can cause some major problems at the beginning of a project, not getting paid if you don't do that right. So from our standpoint, that's what we're really trying to focus on.
Yeah, and a lot of them too will contain provisions that, even if you contest some of the work, you still got to pay for the work you don't contest and what those are and everything else.
Mm-hmm.
And, if you do contest some of the work, there's a procedure that you need to go through, and you've got to send an email and notification to this particular person at this particular time. And you've only got, so long to challenge it. Otherwise it's, considered you accepted. And there are all kinds of terms in there and everything. And you just want to be very clear about what it is. Aside from the business decision, again, I only see it when things go wrong, right? So there's that of like, okay, when things, if and when things go wrong, what do we do on that end? Because, people will say, well, you didn't meet your obligations to properly notify us and to properly challenge that you had an issue with this invoice or anything else. So you've waived it, and so you're just out.
Tough.
And yeah, exactly. So, there's other words to be used there that all start with, that all have 4 letters, but it's just that function of make sure again, what it is your responsibility is. Doing the work isn't always enough. You've got to know the proper protocols of using their software, putting it through their system, coding it. You've got to put an invoice number on it. You've got to put a client on it. You've got to, do all of these things. And it's a little hoop jumping, but at the end of the day, it's your business. So jump, my friend. You jump through the hoops. That's what you got to do.
Eat your greens, boy.
That's it.
Warranties.
Yeah.
Typically, most service agreements or you, Dudley Land Company, will warrant everything. You warrant this, you warrant that. And we always try to avoid it. Oftentimes the nature of our work is it's not warranted. There are a lot of unknowns. There are a lot of decisions you have to make. And again, I'm speaking from the land services, the landman's hat, the field landman's hat. There are certain assumptions you have to make, and there's certain uncertainty in title, uncertainty in the things you might do, because you're always trying to balance urgency with accuracy, and then cost, right? You can spin your wheels to try to, get something perfect such that you can warrant it. But when it boils down to it, we're not attorneys. That's what Oliva Gibbs is for. They'll warrant all day. They may not, but you want to that's something you need to look at. You want to make sure that if it's saying you will warrant your product and you will warrant the title you do, or you won't get paid, or you're subject to, even more so, you're subject to damages for a mistake or a misinterpretation. That's a big deal when you're talking about a client who's drilling a $12 million well, right? And so, you need to be cognizant of it. You want to make sure that, you've at least read through that and it's not over or unrealistically burdensome on you as a service provider. If it is and they're not willing to change, it's the business risk.
Yeah, and to your point is, some of these folks that have the same, the same MSA for landmen, for folks that are providing equipment out of the well site or whatever. And so, look, I can understand that in equipment, if you're providing actual equipment, why there may be some warranties that are there, right? Like, so they're going to be operable and they're going to, be up with codes, everything. But has it been the situation where, a service provider, like how you provide services, I provide services. I can't guarantee you any result. I would love to. I would love to look in my magic ball and tell you I can guarantee that this is going to be the result of this case, and it doesn't happen that way. The same way all of the things you're talking about, but has it been a company like yours that's been in that situation where they signed the equipment deal and it says I warrant the services and products that I'm going to provide, and that definition is broad enough to include it, and it's gone and they weren't right, and it's like, well, you warranted it, so now it's on you. Absolutely, it's why we have jobs, and I said it's why I have jobs, and so yeah, it happens all the time. So just take a look at it and make sure that it applies to you to the extent that you can warrant anything. And I don't know that we can in our line of business, that we can warrant anything because it's not mechanical and we don't know the information that's out there. It's like saying, I'm going to guarantee you I'm going to drill here and we're going to get oil or gas.
Gusher. It would be a gusher.
Yeah, that's it. Special port too.
I'm not saying that landman can't guarantee. We got to do what we got to do. But in the terms of an MSA, you want to avoid it if you can.
Correct.
At least if it's unrealistic. Let's see. Change orders.
Yeah.
Change orders, force majeure. I mean, so realistically in the oil and gas space, you don't see change orders very much. Typically, and I'm speaking just from the landman's experience, you set the general scope of work, you set the general area you're going to do it, and you go to work. It's a fluid process. And it's great. It's you could tell it's very refined. It's 100 years of companies and field guys working together, understanding that we're going to have to be nimble, we're going to have to adapt, and it works fine. Where we do tend to see it is more in like the bigger, like a right-of-way job. Hey, you're going to do this, and you're working with an engineering firm who's set a not to exceed, and they're going to receive payment not to exceed X. Well, you may get down the line, they add 6 more miles of pipe, or you had to do a reroute, and you might need to do a change order to adjust your receivable amount. We do unfortunately see it a lot in the renewable space. It's an emerging industry. They're very engineer. They're very used to dealing with construction companies and this, that, and the other on these sites, and they don't provide the flexibility. So as ridiculous as it sounds, it's very common that we give a $2,000 estimate to run title on a tractor to a land, and it costs us $2,500 to do it, and we have to go through a whole change order process. It's a nightmare. Everybody hates it. Everybody's miserable to do it. So avoid change orders if you can. When applicable, it's just really what you want to think about. Is this meaningful? Try to strike it if you can, just from a practicality standpoint. But if it's a big enough job and, you're concerned about payment, maybe you want that structure. So and you just got to think about what you're doing and who your clients are.
Yeah. And to that end, I'm always a fan of something in writing is better. Like a lot of these MSAs will have specific procedures about change orders and how that all looks. But, even if it's like, hey man, I know we talked today and, I appreciate now instead of $2,000, it's going to be $2,500. Send an email to that effect, just of hey, I appreciate it. Like we said, and you guys agreed, so we're going to move forward. Because when it blows up, if it blows up, then it's not, well, no, I talked to Steve and Steve said it was okay. Well, Steve's long gone, right? Steve is no longer there. And
Steve has amnesia all of a sudden.
And if Steve is there, Steve's not going to remember that he okayed outside of his chain of command for you to continue on and everything else. Like it's, again, while everything is going fast and furious and everybody wants to get the work done and, get drilling and get pumping and everything else, man, everybody's holding hands and it's kumbaya. And it's like, yeah, I got you. And, everything. And then as it slows down, as it always does, everybody starts looking and like, why does we pay $2,500 when we only agreed to $2,000? And that's where, we get involved. And if there's an email, look, it doesn't follow the exact protocol of the change order. Okay, no, but it makes it much harder for me to be like, I don't know what they're talking about. Like, it makes it more difficult to say that with an honest face. And so, even though it doesn't happen often, quick emails, I have a entirely different talk and I can spend 3 hours on it as to why we should avoid text messages. But if that's the way you got to go to, just something just quick to note it.
Yeah, for sure.
The next one's force majeure. Is there any crazy stories from that?
Look,
Not in my
COVID
space.
knocked that one out of the park. I mean, from my perspective, like, look,
I've been
20
from
years
years.
ag- yeah, 20 years ago when I was in law school, it was like, well, what if it rains on your wedding day? Like, is that an act of God? And like, can you get out of the contract? And it was like, okay, I mean, it was just kind of this like theoretical, like, look, if lightning strikes and you're supposed to fix something and lightning strikes and destroys it, well, then you're excused from the contract because there's nothing there to fix anymore, right? So that's it. But then, boy, howdy, COVID really, really put this, kind of, I don't want to say obsolete, but really got down on it, and whether or not the COVID pandemic classified as, an act of God or things beyond the control of either one of the parties that, were shutting down, all these types of things. And so massive amounts of litigation have come out about it. Now, most of the MSAs that I have been reviewing, that is like, if there are no other changes, there's a change to that clause that will include pandemic or epidemic, and they will insert those two words into them. So, lessons learned, I guess, of, from COVID.
You got to add that act of China language into your force majeure.
That's it.
Man.
Let's see. So we got termination. Really, from a landman's perspective, we've hit on term and termination. Typically, what you see, the company gets longer or shorter notice to fire you. You have to give them longer notice to fire them. That's just the relationship. It's the one-sided nature of it, and that's fine. Really, the practical thing that you want to address is typically if they're going to go through a process of terminating your work order or terminating your MSA, something went wrong, right? I can't say that I've ever been through the process of a termination, where it got that nasty, where they terminated the service agreement. But you do want to account for things like if they're going to terminate a work order and you are working for a client that's very proper with their maintenance up there, terminating their work orders and things like that, that you account for demobilization. If you've got people in the field, and I'm putting the layman's hat on. If you have people in the field and they're in North Dakota and they moved an RV up there and, or they're working in the courthouse or they're doing whatever, and the client calls, says, stop today. Well, like, these people are, it's going to take me an hour to call all these people, and they need to demobilize. They maybe need to secure all the commitments that they had, finish leasing, do whatever that your instructions do. So I always just try to add, will be paid for the services rendered up to termination and any demobilization thereafter. And it covers you. Again, not a problem until it's a problem. So you just want to try to account for it.
Yeah, and I just want to back up real quick and hit the liability and indemnification section. It's probably the most important outside of getting paid and everything provision in these MSAs. The goal is, again, big picture is you're going to handle your business. I'm going to handle my business. I'll be responsible for what I do. You be responsible for what you do. And even though the concept is that simple, the wording gets horrifically mangled a lot of the times. And
Every time.
and states, Texas has its own requirements. Louisiana has its own requirements. There are anti-indemnity acts, but then there are safe harbor provisions. There are all of these different things. And even though folks that mean well don't always get it right. And so if nothing else, it's my recommendation to have somebody take a look at just that specific provision and say, does this meet with wherever we're doing the work and the requirements that we want? We look at Texas ones all the time. Does this say what I think it says? It's going to have company group defined. It's going to have contractor group defined, and it's going to be you and the independent contractors and your subcontractors and their subcontractors of all tiers and affiliates. And anyway, you want to make sure you know what you're signing up for. And then a lot of times with that, as Brett was talking about, is, there's insurance requirements. Do you have the right insurance? And you have different things. We've sent MSAs that talk about, providing for maritime and longshoremen. And they're like, well, this isn't applicable. We don't need this. Great. Cross that off. Fantastic. I don't want people to have insurance they don't need to have, but I do want them to have the level that they do need to have and what makes sense of different things. And those can get real tricky. And it's probably where I've seen the most litigation come out of is on that liability and indemnification clauses. in MSAs, and it's hugely important. So I apologize for backtracking a little bit, but it's
I think I
it's
actually
a
skipped it.
it's a good
I
deal.
did
Yeah,
skip it.
yeah.
It is a big deal.
And it's a pain. It's a real that's like the Brussels sprouts before Brussels sprouts went through this renovation of the greens. It's tough sledding there.
Yeah, the simple fix, and it's probably about a 50-50 roll of the dice how willing our clients are willing to work with us on modifications to that language, because they know it's that important. Like their legal is like, put it all on them. And we're like, I can't carry that. But typically, if I just try to think of cross indemnity instead of I will be, you indemnify me, it's we will indemnify each other, and the other party, and just kind of really add that language so that instead of it being pointed one way, it flows both ways, as Molly referenced. And really that's, if you kind of keep it simple, generally you can work it through. If you get too heavy with the pen, then some attorney will see it and say, well, they're working for us.
Yeah. And in Texas, you actually have to write the word negligence. Like, just do it, right? There's the express negligence rule, and you don't, just make it easier. Just use the word negligence in there.
That's right. You got
That's
it.
what I got. Yeah.
There's typically, and you see it, another thing to hit on is kind of outside of that is it might fall under miscellaneous provisions, but it's kind of in the same vein. I see it a lot in this part of an MSA. It's the lien language, right? And most MSAs will say, you service provider will not cause a lien to be placed on, my assets, right? And I get that, right? And it's very hard to get that out of an agreement in general. The compromise for us tends to be, we will not allow a justifiable lien to be placed on your assets. There's nothing stopping anyone from filing a lien on anything. That's just the reality. I can have some crazy somebody file a lien on something they have no right. As a service provider, you need to be able to at least defend, right? You got to be able to defend an unjustifiable lien. I need to be able to dispute it, get it waived, get it pushed out, instead of being forced to settle it. Like a lot of MSAs say I have to. They say you shall not let a lien be filed. And therefore the implications, you have to settle it. Who wants to do that? It may not be justified. And we've had that happen through our career, through our times, a number of times. Some crazy somebody files some crazy lien, and we got to go, get it cleaned up. So as a service provider, if you can just put language that says, you have to be able to, no unjustified lien shall be filed. Typically, if they're reasonable, they'll understand that and let it go. Little note there from history, past experience. Yeah. Insurance is the big one. Oh, we went into confidentiality. That's a pretty important. We've touched on it. We don't have to dive into it too much, I don't think. Most MSAs are going to have it 12 months after you finish working. You can't disclose anything, yada, yada. That's pretty straightforward. Molly probably has a tremendous amount of case law and litigation behind the nuance of it. But from a practical standpoint as landmen, you want to adhere to your code of ethics. You want to keep information confidential. And I never mark through anything in a confidentiality provision, in general. Go into a good faith. Our business practices keep that confidential. And if you're doing things as you should be, you're not risking information getting out there. But what is always at the bottom of that in our space is the non-compete language. It usually falls in right behind it in that paragraph. And again, I touched on it earlier. Typical kind of industry standard is 12 months after you finish working. But you want to address scope. You want to define what's going to create a non-compete area, and you want to define, how that's going to look. Is it tied to the geographic area? Is it a mile outside of it? Is it 5 miles outside of it? You want to understand those things. And if you're running a good firm, you want to be able to monitor it. And that's the biggest thing. You want it to be concrete enough such that you can define it, track it, and adhere to it. I think there's a lot of trust that goes into hiring a broker. And I think if you're going to sign off on that as a service provider, you need to be able to adhere to it. So you want to protect yourself from not being overly burdened with non-compete I mentioned it earlier, short-term job, a big, broad, in-house staffing project. We see that all the time. We're doing a top secret leasing job for someone. but then we staff someone in house as well, and they've got them working on, pay decks and division orders and projects at a corporate level that are, across entire counties. Well, you want to clarify that in your non-compete, such that if I'm doing leasing for you, then I'm exclusive to you for a period of time after I'm done. But if I'm doing this broad sweeping project, well, that's not going to create a non-compete.
Yeah. Courts don't love non-competes, right? Because they want people to be able to move and, work as they need to and everything. But all reiterating everything that you just said, specificity, term limits, what's actually you're trying to keep confidential, that'll be enforced, as long as it's reasonable, is the big thing. The courts will uphold all of that stuff and hold people to that, and penalties can ensue if there's a violation. So yeah, just be specific and include a term. And 12 months is right in the wheelhouse. So
Right in the sweet spot. It's the most
yeah,
emotional reaction that I get from clients. It's as a landman, if you're dealing with a land manager, they're very aware of that. They're very aware of like, what we're hiring you to do is confidential, it's top secret. I don't want you coming in my block. So typically when I mark that up, it always comes with a phone call to explain why, that, I'm not trying to be able to go buy minerals in your area, but these are the real world circumstances that, potentially I could be in violation just by going through a normal course of business. So it's good to address it. It's good to also talk through it with whoever you're working through so that they understand your perspective.
yeah.
Dispute resolution, basically, again, Molly could probably go for days. The practical thing is there's not a dispute until there's a problem. And most of the time it just, the reality is, as a service provider, if there's a dispute, you're just not going to get paid, as a landman, as a service provider, you, as a professional service provider, you can't go file a lien on someone. It's not upheld, right? As a landman. So it's in most MSAs. Typically I don't even mark through it. It's like, okay, it is what it is. We're subject to this and you can do that. Molly can give probably a lot more detailed and maybe some nuance to that. I'd love to kind of hear if I'm just glossing over this.
No,
With me.
look, it's going to, again, the MSA it defines the general outward or the general framework and everything. And so look, typically there's arbitration provisions in there, which in oil and gas and in other businesses as well, not just in oil and gas, but the thought is that if you can go to arbitration, there's either a, 1 to 3 judge panel, sometimes 5, and they are folks that know this business, right? So you don't have to say, well, here's what an MSA is, or, here's what a landman does. They know that. They know the business. They've practiced in the business. They've practiced law in the business. They may be landmen themselves. So they know that. And so there's a level of sophistication that's presumed there that allows the parties to say, this is what the dispute is, and not start with, the very, very beginning and the very basics of explaining it to the way that you may have to with a jury. Again, pros and cons on each side, right? So pros, sophisticated folks know the business, know how it works, know what actually happens as opposed to what we put on paper happens, those types of things. Cons to that, they typically split the baby. It's rare that one side is absolutely going to win and get everything that they want, or that one side's going to win and pay $0.00. Does it happen? Sure. But it's the rare thing. It's like, okay, how does somebody get a little bit of everything? Mediation is like most, even if you go to standard litigation, you're going to go to mediation anyway. So those aren't as typical things that we see, but sometimes MSAs will say, we've got to go to mediation before you can file a lawsuit and see if we can resolve this. Look, I am the biggest proponent of, if you can avoid litigation, do it. I'm here if you need me, but if you can avoid it, by all means do it. It's costly, it's expensive. Nobody gets what they want out of the whole thing. It can ruin business relationships. Your company's tied up. Your employees are tied up. You're having to answer my phone calls and deal with this and go to hearings and, all these types of things. So if you can avoid it, absolutely. So sometimes a mediation before filing a lawsuit can be beneficial to say, look, all right, everybody cool off, back to your corners. All right, let's sit down and let's have a conversation and figure out what we can move and agree to. And then certainly, take a look at the jurisdiction as to where the suit's going to be filed. I mean, I can break down county by county in Texas about where are better counties, but it all depends. 10 years ago, I'd say, great, Dallas County, Harris County, awesome, file suits there all day long. And now I'm like, nope, those juries, they are pro plaintiff juries, which may be good for you if that's the side you're on. But they are returning very large, very high verdicts. So just pay attention to that. In New Mexico there's some other things that, you may not want to be in New Mexico depending on different reasons if you can avoid it and some other things. So, that certainly bleeds into kind of the final one, which is have somebody take a look at it. Anybody lawyers or anything that would take a look at it would certainly have some opinions about that. In which venues are more friendly or not. But yeah, there's some, again, avoid litigation at all costs. Avoid it, which I get is counterintuitive to me being a litigator in oil and gas. But yeah, so if
Well,
there
that's
are
how
other
you can
ways
charge
around it.
such high rates.
Well,
That's
yeah, I mean,
valuable.
I got to
when
make
you're there.
up for it.
When
Yeah,
you
I got to
need me,
make
you
up
need
for
me.
it. That's it. Yeah, call me now or call me later, right? So,
That's right.
but yeah, so they are important. I care about them, right? You guys, it's not going to affect how you guys do your business and your services that you're providing or anything, but I certainly care. And if I get to set the chess pieces a little bit beforehand, then that's something I want to do.
Yeah. That kind of gets us down to the end. I mean, miscellaneous provisions, they're generally boilerplate stuff, not anything you really need to focus on. The one thing that we will tend to add, and again, it depends on the client and the industry that we're working in, is a non-solicitation. Especially if, I'm staffing people or it's a startup company and we're integral to actually getting up off the ground. Typically you're going to put one of your better people. You're going to, maybe someone you've invested a lot of time and money into developing. And, I just want to say that you can't just go hire all my people. I'm not here to be a staffing company for you. I'm not charging you staffing rates. This is not a staffing arrangement. So I try to add that. Some industries, it's a little more important than others. I don't want to point fingers and name names, but if you're in an industry where your people are valuable and the expertise that you're bringing to the table is valuable, you want to make sure that you're just not leaving an open door. And if you feel like it might be a scenario where they might want to pull your people or hire your people, you might want to consider, adding that kind of language that says, okay, if you're going to hire someone, this is what you will pay me for that person. Just like you would see in any kind of staffing arrangement when you use a staffing company. So you can find a billion examples of language on the internet for that, but it's a consideration. And we do add that to all of our service agreements in certain spaces to ensure that if you're going to poach somebody from me, you're going to pay the price. Because, as a service provider, you invest a lot of time and money in finding these people and cultivating them and keeping them busy and developing them. So you want to protect your assets as a service provider. Sure. Then you get down to the schedule of attachments. Typically what we see in schedules, and we've touched on all this, is the insurance requirements. Again, we'll flip through that. Typically there's going to be 8 or 10 different types of insurances on some of the bigger MSAs. Most times you can strike them out if it's something that doesn't apply. As a landman, you don't need to have, intercontinental oceaneering ship maintenance insurance, I mean,
watercraft is a big one.
Watercraft is the best one. Yeah. Unless you're going to be bass fishing while you're billing a day rate, you don't need it. So typical, what we see as standard is, general liability, workman's compensation insurance, auto insurance. You see some E&O, professional liability insurance requirements more and more. Don't get me on my rant about that as a landman, but is what it is. So you'll see those things. Those are typical and standard. You just want to make sure you have enough to cover that, whatever the requirements are. And I would say from a practical standpoint, if it's some absurd amount, $10 million, and you strike it out to $5 million of general liability, or umbrella policy or whatever it might be, most of the times they'll work with that, So you have a little freedom there. And then the rest of the other exhibits that we tend to see are the work orders. And that's where really that's where your rates are set out. That's where your expense and reimbursement policy is. I can say of all the years that I've been doing this and all the clients that we work for, that when things go south, it's because of the work order. It's because of the rate schedule. It's because of the expense and reimbursement policy in the rates in that work order, and your maybe compliance or non-compliance with it. That's where it gets you. It's always in those things that are, you said this and you did that, in our space, right? So I put a ton of emphasis on it. We have a whole process when we sign an MSA. This is the rate schedule. This is that. It goes straight to someone. It goes in the system so that, we adhere to that. Do things fall through the cracks? Absolutely. Most of the time when it falls through the cracks is because you're moving people on and off of jobs. You're cycling from one project to another. You maybe started the project or the relationship with your client as a field landman doing title, and then they hire you to do due diligence, and you got to bring in an in-house landman whose day rate is $100 higher. And then the hectic chaos of providing your services, you put that person on there and all of a sudden you're out of compliance, right? And that company a year later or 6 months later does an audit, and Dudley was billing $100 a day for this person more than they were authorized to do. Well, it's not that you were cheating the system. It's just you got caught up in doing the work. So pay attention to it. The expense reimbursement is a big deal. I've had 10-year relationships with clients go south because, we build a 20-man job at $35 meal reimbursement instead of 25. Or we were trucking people, sending people to some remote place, and we build more mobilization miles than we should have. It's those little things that'll just kill you. And I'm super passionate about it because I had it happen last week on a job, a pipeline project where, pipeline job for typical upstream, exploration and development client that we had, and they needed us to do a pipeline. So we put pipeline hats on, we put pipeline project managers on it, and right-of-way agents on it, and they rolled under their normal course of business for billing you using a per diem as opposed to $30 a day for meals. And you can only bill X amount of miles to get to the job site, and you can't bill for weekends and all these things in our work order that were specific to a certain type of work that we blew through and just dropped the ball and didn't adhere to that because we put a different hat on. So things went south. Client was all pissed off and upset at us, and I had to eat crow. So yeah, you know what? We botched it. We were operating within industry standards for right of way, but that's not what our MSA read, and that's not what the work order read. And it ended up costing us a lot of money. It cost my landmen a lot of money. We all had to eat a little bit, take a haircut, and it could have very much been avoidable. So the parting advice for all my broker buddies out there, maybe I shouldn't give this advice, just have them screw it up and tell us, but
No,
it's
that's
important.
it's a good lesson learned. And, it's always so much of these things of, unfortunately, sometimes these things got to go wrong until you get them right a little bit. And, I mean, it's one of those things, I'm sure you're never going to make that mistake again. And it's the second pipeline enters, you're like, okay, hang on, Mike. And now, it's all going to be,
What toots mass? It
yeah,
was,
that's
it
it.
happened,
Yeah.
but it just happens. It's those little things. And I guess to put a bow on this whole thing is you want to go through these agreements as from our perspective, trying to make sure that you can live by it through your normal course of business. You don't want to live by exception. If you're working for multiple clients, you don't want to have to think one way for this client and think that way for another. Try to get it as streamlined with how you tend to operate as you can, and rock and roll and pay attention to it. That's important.
Well, and from my perspective, right, I'm the fun police, right? So you guys just want to get work and go out there and get it, get guys on the job, get it going, get paid, and what can you do from a business perspective? And that's the way you're looking at it. Send it to me. I'll take a look at it and let you know. All right, when all this goes south, if this goes south, here's what's going to happen, and here's some other things. Can you live with it? Can you not live with it? And are you protected? And so that if and when things do go wrong, it's that. So yeah, I'll read all the provisions you don't want to read. You want to read the ones of what do I have to do and how much am I going to get paid, and I'll read all the other ones in between and make sure that that's all taken care of.
That's right. Molly, do y'all have an at Oliva Gibbs, do you have a standard kind of boilerplate? Can people reach out to y'all for maybe if they need something to start, or maybe want you guys to review their standard agreement?
Absolutely. Absolutely. We do it fairly regularly. We can, if you are presented with an MSA and you're like, I just want somebody to take a look at it, shoot it over to us. We'll take a look at it. And we've got other clients that say, look, I'm just going to start over with our MSAs, and every vendor that we deal with, let's put together something that works for us, and get it out to them. And they're in that 3 to 5 year cycle. And so they're doing it kind of soup to nuts. But yeah, wherever you are in the process, we certainly can help out and take a look at all these things and guide you through that process, because it can be a little daunting.
Well, thank you so much, Molly, for joining us, for sharing all about MSAs. We'll link to that article, Navigating the Master Service Agreement, and also you can get in touch through oglawyers.com. Is that right?
Yes, sir.
Okay. Well, thanks for being on the Land
Greatest
Department.
website name of all time, by the way. Y'all have the coolest lawyer name. As a kid from the 90s, like. Awesome.
great.
Thank you, Molly. Really,
Of course.
really appreciate it.
Thanks.
Thanks for listening to The Land Department. Check out our website in the show notes or visit dudley-land.com to learn more about us.